Good morning, everyone. My name is Olivia, and today I'm going to be talking about two things extremely interesting and important to me. So I hope you all enjoy it, and if I bore you to death, I'm so sorry, but I have to do this anyway. So I'm going to discuss litigation and Marvel Comics, and what litigation is it's the process of taking legal action, so like suing someone. And we're going to discuss a few cases throughout my presentation, but to begin with, I want to start with a quote from Stan Lee, may he rest in peace. And so the quote reads, if you are interested in what you are doing, that keeps you going. This resonates with me because I've always loved law and like all of the aspects surrounding it. I find intellectual property, which is what I'm going to really be talking about, the most interesting because it's what I want to do when I go to law school and everything. And I actually, when I was starting to do this, I looked it up, and basically Marvel hires intellectual property attorneys, so like the fact that I could potentially work for them one day was the coolest thing I had read that day. Yeah, I don't really have a life, but it's fine. So let's get this presentation started. So Marvel Comics is referred to as one of the big two. DC Comics is the other one. Their parent company is Marvel Entertainment, and they are owned by Disney. So as you can all see, I put up this really cool timeline, but it kind of just shows the cinematic universe from 2008, which started with the Hulk and Iron Man and ends this year with Endgame, which hasn't come out yet. But I found it really interesting in just like the span of 11 years to see how much, like how far they've come. But anyway, so it was founded by pulp magazine publisher Martin Goodman in 1939. And so the licensing, like Marvel was just associated with geeky boys back in the day, and it's now a multi-billion-dollar corporation. And the fact that people haven't claimed sexism because geeky boys actually shocks me, but it's fine. So intellectual property protects comics in two ways, which is copyright and trademark law. As you can all see, copyright law protects the original works of authorship, while trademark law protects the business's commercial identity or brand, so the company's name, Marvel, like the little TM that you saw at like the opening screen, like means trademark. The broad idea of comics, however, is not protected by copyright law. So to explain, I could be standing here discussing this whole new comic book idea that I had. Like this character, like a storyline, a name, everything. In that case, I could have the comic protected by copyright law. However, until I have a whole story, I just have a specific idea, and that's not protected. So trademark protection, it's used to protect the names and likenesses of Marvel comic book superheroes, so like Iron Man, Captain America, Thor. It's literally Marvel's key to build and secure a sizable revenue. And then, this is actually interesting, Marvel and DC co-registered the name superheroes for toys and comic books, so it's, yeah, copyright. Granted, a lot of intellectual property attorneys find that to be ridiculous since the term superheroes is very broad. So I could stand here and you guys could be like, oh, you're a superhero. Yeah, well, it's a broad idea, so, but you kind of can't use that to label me because copyright. But anyway, so according to WIPO magazine, when artistic creations are produced, they are considered works for hire, and the copyright in these works automatically vests in the employer. But why is this important? So in 2009, the estate of comic book artist Jack Kirby brought forward a case to assert rights in a number of works he co-created between 1958 and 1963, such as he worked on Captain America, Thor, Iron Man, Inhumans, and even the Fantastic Four. The United States District Court, Southern District of New York, stated that Marvel held copyright privileges to the works created by him. They stated that his work qualifies as work for hire under the U.S. Copyright Act of 1909. And then according to uslegal.com, the act grants copyright protection to originally published work for a period of 28 years. And so every 28 years, though, people can like reamp the, what's the word I'm looking for, the protection. Like they can every 28 years. So like with songs, like you can have it protected every year and people can't steal your work. So the court concluded that Kirby did not complete the work until Stan Lee told him to, therefore he did not own the copyright to those works. Jack Kirby most likely did not expect for his work to become so popular in this multi-billion-dollar corporation, nor the evolution of copyright law to where it is now. This shows just how important it is for creators to understand the ins and outs of copyright law. So the Kirby family today notified the Supreme Court, yes, the Supreme Court of the United States of America, that they wanted their petition dismissed for, getting his rights and everything. And it was a long legal road for them and Marvel to get to a deal. They failed repeatedly in lower courts, and Lisa, Neil, Susan, and Barbara Kirby petitioned to the Supreme Court on March 21st for a hearing on the matter. In their petition, they wanted SCOTUS to rule in favor of their assertion that they had the right in 2009 to issue termination notices on 262 works that Kirby helped create between 1958 and 1963. 45 of those notices went out to Marvel, Disney, Fox, Sony, Universal, and Paramount Pictures, and others who have made film based on his characters under the provisions of the 1976 Copyright Act. So Marvel sued in 2010 after failing to reach an agreement back then with the Kirby family to invalidate the termination notices. In the end, however, Marvel and Jack Kirby's family have resolved their legal disputes and are looking forward to advancing their shared goal of honoring his significant role in Marvel's history. All things considered, though, with the billions that Marvel and Disney have made off the films with characters he created, this deal should have made no dent in any of their pockets, except for the fact it took them so long. So clearly they have no patience. But regarding the movies, really quick, Marvel Studios is a full-fledged filmmaker. They were bound by pre-existing movie licensing agreements. So a lot of their characters they can't actually use. Kevin Feige, the studio's president, actually said the contracts are all very specific, and if there is ever a time for them to revert, they will, but right now they are safely at those studios. For example, Spider-Man, for the longest time, has been owned by Sony. The 3 original Spider-Man movies with Tobey Maguire, which in my opinion were not that good because they were not worked on by Marvel at all. Sony just owned it. It was the same with the Amazing Spider-Man movies, which was with Andrew Garfield. Again, Sony made both. I'm biased though, those were honestly better than the original 3. And then Sony and Marvel worked together on Spider-Man Homecoming, which is with Tom Holland. And watch them reboot Spider-Man for a 4th time, and everyone hates the next person. So Marvel, but more so Disney, just bought the rights to 20th Century Fox, so they can now make movies including Deadpool and X-Men, whereas Sony still owns Spider-Man. I believe they will be working closely from now on, though, especially since they did on Homecoming, and then they incorporated Spider-Man into Captain America Civil War. But regarding the Jack Kirby case, it obviously didn't work out, but another case I'm going to mention is that when Stan Lee sued Marvel. So Stan Lee sued Marvel in 2002 for not fulfilling the terms of his employment contract. Beginning in 2002, with the CBS show 60 Minutes 2, they aired a story discussing how Lee had a potential skirmish with Marvel. In his contract, there were terms and conditions regarding payments that he deserved. This was due to the soaring box office numbers of both Spider-Man movies, 1 and 2. And at first it was as though his contract seemed straightforward, so obviously he did not read the fine print. But no one was expecting 2000's X-Men to earn nearly $300 million worldwide, and for Spider-Man to draw in $821 million. When it was in theaters. So days after that segment aired, Lee actually sued Marvel. So they were sued on the grounds for not honoring the stipulation that promised him 10% of the profits from Marvel Enterprise film and television production. This actually brought up the argument of Jack Kirby again and how he was treated and how obviously it didn't really work out in his favor. Rehashing the case caused Lee to make a fortune off of the success, except it also made people really dislike him. mainly because, like Lee, Kirby worked on many comics with other people and he never received his recognition. Although critics said that Lee got rich off the lawsuit and Kirby made absolutely nothing. So in early 2005, April 28th to be exact, the judge presiding over the case ruled in favor of Stan Lee. Marvel's payoff to Lee was about $10 million, and I'm pretty sure during this whole ordeal, both of them, both the company and Stan Lee, were thinking this. So, despite the lawsuit, Marvel pushed forward with their own movies, and since X-Men at the time was owned by 20th Century Fox, which is now owned by Disney, and Spider-Man is owned to this day by Sony Pictures, this did not stop Marvel, and they began their billion-dollar enterprise, which came out in 2008, starting with Iron Man. And we can actually thank Merrill Lynch & Co. for this because they gave Marvel $525 million to start this enterprise, but they used 10 of their characters as collateral damage in case it failed. So Disney bought Marvel Entertainment for $4 billion in 2009. In 2012, Marvel earned about $6 billion in retail sales, mainly because the Avengers had just been released. However, now with Avengers Infinity War having come out last year, they brought in over $600 billion in its first weekend of being released. So really quick, I'm going to mention an article from thelegalgeeks.com about their Marvel's copyright loss. So it was written by the user @JessicaALegalGeek. She began by pointing out that she read the book Marvel Comics: The Untold Story and how large of a difference between Marvel and DC there is. Mainly pointing out that Marvel characters are from real cities. So like Spider-Man is from Queens, Captain America's from Brooklyn, and then, and Batman's from Gotham and Superman's from Krypton. And so, as you all know, Stan Lee changed the way of writing comics. This came to be known as the Marvel Method, which is a script that involves all the dialogue and run-through of necessary scenes, art, etc. Basically, the method leaves the layout of the pages to the discretion of the artists. So the plot is typically derived via a story conference between the scripter and the artist. The pages are drawn, the scripter adds dialogue to the drawn pages, but the drawback in this method is that if the artist didn't do a good enough job on the pages, the editor, in the case of Marvel, the editor was also the scripter of the issue, would have the artist redo the pages until the story was right. But anyway, going back to what I said earlier, under U.S. law, the creations of Stan Lee and Jack Kirby never really belonged to them. In general, copyright protection is established in a moment of creation, but under Section 106 of the 1976 Copyright Act, the owner of copyright, usually the author, has exclusive rights. But since Marvel was a work-for-hire company, the legal author is the employer, and as we all know, Stan Lee made out better than Jack Kirby did, but we already discussed that. So really quick, just a couple of honorable mentions, as you can see. Howard the Duck, I actually haven't seen, but everyone who's seen it says it was terrible. There was a lawsuit that started in 1980 with Steve Gerber. He wanted creative control over the character, and this dispute ended up not being made public, so I'm not sure if he ever got his rights or how the case ended as a whole. I literally could not find anything. In 1989, over a decade later, when Blade, also haven't seen that one, was set to hit theaters, Marv Wolfman, the creator, filed a lawsuit. He claimed, like Jack Kirby and Stan Lee, that he was not bound by the work-for-hire contract when Blade was created in 1972. He ended up losing, but his case actually ended up showing fans that superhero movies did not always benefit the writers and artists. Then lastly, Gary Frederick filed a lawsuit over his rights to Ghost Rider, which I have seen. And according to the final judgment, Frederick actually ended up owing Marvel $17,000 because he was stupid and sold memorabilia at a convention. In the end, however, Frederick and Marvel settled out of court in a civil decision. So just to recap, I discussed Marvel's history and founding. I discussed intellectual property protection, how the broad idea of comics is not protected, why copyright is extremely important. I talked about the cases of Jack Kirby's family and then Stan Lee, who obviously made out better. I discussed Disney buying 20th Century Fox and how Merrill Lynch, I didn't really dive into this, but they kind of started, what Marvel is today, and then I kind of just touched on a few other lawsuits. So I hope you found this all interesting because I had a lot of fun making it, and if you have any questions, I will take them now.